This is not breaking news. This is not a scandal. This is not about one person. This is a quiet, procedural change that turns the country into a map of exceptions. Not 50 states, 50 realities. A thing that used to stop a law everywhere can now stop it only somewhere. And when that somewhere changes, the rules change with it. Not next year, not after a commission, fast, unannounced, on a clock you don't control. If you've ever assumed your rights travel with you, like your name does, that assumption is now in play. And the most dangerous part is you won't feel it happen all at once. You'll feel it in fragments, in crossings, in errands. So stay with me. Subscribe if you want the next turn of this before it hits you, because the mechanism that makes this possible is already moving, and it doesn't need your permission. What actually controls the system now is not the law as written. It's the ability to freeze the law for 20 years. The fastest way to win wasn't to persuade the country. It was to find one courtroom, one judge, one order. And suddenly a rule made in one state or one agency could be stopped everywhere. That wasn't democracy. That wasn't even federalism. That was leverage. And now the court has pulled that lever out of the hands of lower judges. Not slowly, not politely, on an emergency docket. By a 6-3 vote, the surface story is procedure, but the deeper frame is power. Who gets to set the default when America disagrees with itself? Because when nationwide relief disappears, the system doesn't become calmer, it becomes fragmented. And fragmentation is not neutral. It rewards the side with money, manpower, and stamina. And it punishes everyone who assumed the Constitution was supposed to be one thing in one country at one time. And that takes us to the silent shift that made this moment inevitable. Before, when a major fight hit the courts, the country could hold its breath together. A single ruling could pause enforcement. Nationwide, immediate, clean lines, clear rules. Now imagine the same fight, but split into pieces. A law blocked in one district, alive in another, paused for some people, fully enforced on everyone else. That is not just messy. It is a slow motion redesign of what equal protection feels like in real life. And here's the silent shift. We normalize the idea that rights can be managed like software updates, pushed out in patches, rolled back in emergencies, limited by jurisdiction, subject to where the lawsuit landed, not where the harm landed. This change didn't need a constitutional amendment. It didn't need Congress. It didn't even need a big landmark case. It just needed repetition, judge by judge, order by order, until it felt normal. And once something that big feels normal, it stops looking like danger. It starts looking like background. But the background is where systems fail first. Because the moment those clean lines disappear, the first shock doesn't arrive as theory. It arrives as enforcement. In the material you gave me, the warning isn't abstract, it's operational. There are already dozens of active fights built on the old assumption that one judge could freeze a rule everywhere. More than 60 nationwide injunctions in the last decade, and right now, dozens more cases queued up, asking for that same kind of blanket stop. And then the emergency ruling lands, and within hours, states start moving emergency filings, fast citations, new briefs dropped into old cases like gasoline into a room with no windows. Because the incentive flips overnight, if a law has been frozen, governors don't wait for clarity. They prepare enforcement. If a policy has been blocked, agencies don't assume it stays blocked. They prepare to restart. So instead of one national question, is this allowed? You get 50 smaller ones. Where is this allowed? Who is protected? Who isn't? How far does the order reach? How long before it changes? And the cliff edge is this. When the rules splinter fast enough, the first people to feel it aren't political operatives. It's the public waking up to a law that was stopped until it wasn't. Here's the mechanism. And once you see it, you can't unsee it. When nationwide injunctions shrink, The fight doesn't disappear. It multiplies. Instead of one case that pauses a policy across the country, you get a swarm of cases. 15 filings, 20 filings, different judges, different circuits, different timelines. That means the side with the most resources doesn't just have an advantage. They get 2 times manufacture reality asterisk. They can afford parallel lawsuits, parallel appeals, parallel strategies in multiple districts at once. Everyone else gets stuck living under whatever rule is currently enforceable where they happen to stand. And that's the real redistribution happening here. Not left to right, not red to blue. It's from people who need clarity to institutions that can survive chaos. Because chaos has a price. Attorney time, compliance systems, paperwork, emergency meetings. And the people who can pay that price can keep playing until they win. Meanwhile, the damage doesn't wait for the final verdict. The damage happens in the gap between rulings. And once the system starts running on gaps, it doesn't slow down. It accelerates into the next crisis where the stakes aren't paperwork, they're lives. Now the pace changes because the consequences don't arrive as one headline. They arrive as a calendar. Immigration enforcement. 14 different injunctions in play in the reference you provided. Under the new rule, protection can shrink to the named plaintiffs, which means enforcement can restart everywhere else. Second Amendment cases. Gun rules frozen in 6 states, according to your material. If injunctions narrow, rights don't change by Supreme Court opinion. They change by county line. Healthcare access. 11 active cases tied to abortion medication, gender-affirming care, exemptions, a rule blocked for one set of patients, enforced for everyone else, environmental regulations. EPA rules tangled in orders that might stop applying coast to coast, and election law, 9 nationwide injunctions affecting procedures across 19 states. In your reference, is the fuse sitting in plain view? Because election administrators can't run maybe. They can't print ballots for it depends. They can't train poll workers on we'll see. So the system does what systems do when certainty disappears. It defaults to power. And power moves fastest when nobody knows the rules. This is where it stops being a courtroom story and becomes a you story. Because you don't live inside legal doctrine. You live inside deadlines. Pharmacies, schools, jobs, polling places, a drive across town that suddenly crosses an invisible boundary. When the rules splinter, you become your own compliance department. You have to know what's enforceable times here, asterisk, today, and whether here changes if you take the wrong exit. And that pressure lands unevenly. If you have money, you can adapt. If you have time, you can research. If you have a lawyer, you can fight. If you don't, the system doesn't pause for you. It just proceeds. That's the trap of patchwork rights. The harm is ordinary. It looks like paperwork. It looks like confusion. It looks like, sorry, we can't. And the more ordinary it looks, the less anyone notices it's spreading. So if you're still watching, do one thing. Stay close to this story. Subscribe, share it with the person who thinks this is just procedure. Because the next phase isn't about what one state does. It's about what happens when the rest of the world learns America can't keep its rules consistent. When a country can't guarantee uniform rules inside its own borders, it exports uncertainty. Not as an ideology, as a risk profile. Because global systems, trade, finance, migration, tech, depend on something simple, predictability. And what your reference material describes is the opposite. A regulatory rule blocked in one region but enforced in another is not just a legal puzzle. It's a signal to every multinational company standards can fracture overnight. Banking regulations, crypto rules, consumer protection. If injunctions stop being nationwide, compliance stops being national. Technology companies, content moderation, data privacy, antitrust pressure. If the rules shift by circuit, platform policy becomes a moving target, and moving targets attract exploitation. Healthcare providers, insurers, pharma. If enforcement varies by geography, The supply chain stops trusting the map. It starts pricing in chaos. And once chaos is priced in, it doesn't stay on paper. It hits wages, access, investment, hiring, because the world does not pause to let America sort out what counts as law this week. And that's the spillover most people miss. A constitutional system that fragments internally becomes a country that bleeds stability externally. Which brings us to the acceleration point. The future paths this system is already lining up, whether anyone votes for them or not. Now we're at the part where you can feel the slope under your feet. Because once broad relief disappears, there are only 3 paths a system like this can take. Not morally, mechanically. 1, adjustment. Courts and lawmakers adapt to the new limits. Litigation spreads, but procedures solidify. The chaos becomes bureaucratic, predictable, expensive, but contained. 2, erosion. The patchwork becomes permanent. Rules vary not just by state, but by district, by circuit, by timing. Rights become conditional, not because anyone voted to make them conditional, but because nobody can afford to make them uniform. 3, rupture. The system stops tolerating the contradictions. Election rules collide with administration. Regulatory enforcement collides with business reality. Civil rights enforcement collides with geography. And legitimacy becomes the thing on trial. Here's the key. All 3 paths can happen at once, in different arenas, on different timelines. That's what makes it so hard to see. And we still haven't reached the final move embedded in your reference material, the part that tells you who is positioned to benefit from this fragmentation. There's a reason this was done the way your reference describes it. Emergency ruling, fast, immediate. A direct message to lower courts, change course now. And that matters because when rules are unclear, the winners are not the people with the best arguments. They're the people who can move first and keep moving. If relief must be plaintiff by plaintiff, then protection becomes scarce. It becomes something you have to earn times through litigation. And litigation in the world you described is about stamina. So watch what this creates. A country where the same law can be alive and dead at the same time. A country where enforcement depends on geography and geography depends on strategy. A country where rights start to resemble permissions, granted in one place, denied in another, always temporary. And once citizens live inside that kind of uncertainty long enough, they stop asking, what is the rule? They start asking, who is the rule for? That question is corrosive, not dramatic, corrosive. It dissolves trust in slow increments until the increments become a collapse. So here's what I want you to do. Don't treat this like a one-off ruling. Treat it like a new operating system. Subscribe. Stay in the thread. Because the next video goes deeper into the next layer. How a system that fragments rights also fragments responsibility. And who gets to disappear in that fog?